I have worked with hundreds of founder-led businesses over the years. Some have sold for millions, some have raised investment, some have gone from a kitchen table to employing 50 or 60 people almost overnight. And unfortunately, I've also seen businesses totally implode. Not because they weren't good businesses, not because the founders weren't talented or had great ideas, but because they made legal decisions when the business was tiny that came back to haunt them years later. The really frustrating thing is this: almost all of those problems were completely and utterly avoidable. Most founders don't wake up one morning and think, I'm going to make a terrible legal decision today. That's what I'll do. Instead, they tell themselves something we've all heard a million times before. We'll sort that later. We trust each other. We're all friends here. That's my favourite. We'll get the paperwork done once we're making a bit more money. And that is exactly where the trouble starts. Today, I want to walk you through what I genuinely believe are the biggest legal mistakes founders make before their business reaches the 10 million value mark. Because once you understand these key mistakes, you won't just protect your business, you'll make it significantly more valuable in the process. One of the biggest misconceptions that I hear is this: legal is just paperwork. I obviously couldn't disagree more. Good legal structuring is not just about documents, it's about protecting momentum. Think about it this way: businesses don't usually fail because of one catastrophic event. They fail because friction builds over time. A shareholder relationship can deteriorate, an employee can leave holding on to confidential information, an investor asks a question nobody can answer, a buyer starts due diligence and uncovers gaps in the business, a key contractor claims that they own the intellectual property that your business is relying on. Every single one of these problems slows down growth. Every single one costs money. Every single one distracts founders from doing what they are actually good at: growing the business. That is why I often say legal is not there to stop the business taking risks. It's there to stop avoidable risks destroying value. Let's start with what I think is the single biggest mistake that I see founders make: giving away equity too early. Oh my God, we see it all the time. This happens constantly. The business is 6 weeks old. Someone helps build the website. Someone introduces a client to the business. Someone says they'll help with sales. Before anyone really knows whether they're committed, 10% of the business has gone. 20% of the business has gone. Sometimes 50% if they really don't have the right advice. And then reality hits home. That person suddenly loses interest, they go get another job, they move abroad, they start another business, or they simply contribute far less than everyone expected. It was one introduction they made, but they still own part of that company forever. I've seen founders spending years trying to buy back equity that should never have been given away in the first place, and people hang on to equity pretty strongly. I've seen businesses become impossible to sell because somebody who contributed for 3 months owns 25% of the business. Think about that. 3 months effort, permanent ownership of a business that you are growing in value. That's an extraordinary outcome for that person. One of the questions that I often ask founders is this: if you knew today what you know now, would you still have given that person those shares? Hardly anybody says yes to that question, because hindsight is 20/20 and hindsight is wonderful. Unfortunately, the Companies House Register doesn't operate on hindsight. Once shares have been issued, unwinding them can become extremely expensive, awkward, and sometimes impossible. So what is the better approach? Earned equity. Instead of saying, right, here's 20% of the business, say, we'd like you to earn up to 20% over 4 years. Now we're aligning incentives. If they stay, if they contribute, if they build value in the business, then they receive the equity. If they leave after 6 months and they're no longer interested, they don't walk away owning a large proportion of the business and holding up your growth. That single change can save founders hundreds of thousands of pounds later down the line. Which brings me neatly onto founder vesting. This is something that founders often think only applies to Silicon Valley startups. It absolutely does not. Vesting is simply a mechanism for making sure ownership properly reflects contribution. Imagine you have two founders, both own 50% in the company. 6 months later, one of those founders leaves. The other spends the next 7 years building a £15 million company. Without reverse vesting, the person who left still owns half. Think about how unfair that actually feels. One founder built up the value. The other just happened to be there at the beginning, so they just got lucky. That's why vesting has become so common. Not because it's really fashionable, but because it is fair. The second major mistake I see, not having a shareholders agreement early enough. Honestly, I could probably make an entire podcast just about this, because almost every single founder says the same thing. We don't need one. We're best friends. I've known them for years. We're on the same page. Or we're brothers. We're family. Or we've worked together for 20 years. Let me tell you something. I've never drafted a shareholders agreement because people didn't trust each other. It just doesn't happen. I've drafted them because relationships change. Businesses change. Life changes. People get divorced, people become ill, people move overseas, people retire, people disagree on key things that affect the business. The document isn't there because today's relationship is bad, it's there because today's relationship is good. That's exactly when sensible people agree what happens if circumstances change. Imagine you have two shareholders, they're 50-50, everything's going brilliantly. Then one day they fundamentally disagree and neither of them will compromise. Neither can outvote the other. The business stops. Staff don't know what to do. Customers become a little bit nervous. Suppliers lose confidence and faith in the business. All because nobody asked one simple question at the beginning. What happens if we disagree? That's what a good shareholders agreement will answer. A good agreement isn't just about share transfers. It's about governance. It's about decision making, reserved matters, dividend policy, deadlock situations, levers, restrictive covenants, future investment, future dilution, exit strategy. In many ways, it's actually a business document more than a legal document because it forces founders to have conversations that they probably should have had anyway. Now, here's something that I find really fascinating. Founders will spend 6 months writing a business plan, a year refining their product, thousands on branding, thousands on a website. Then they'll spend about 10 minutes discussing ownership. The ownership of the entire business that they are growing to significant value. It's extraordinary when you think about it. Now, here's the third mistake I see. Not owning your own intellectual property. This one genuinely comes as a bit of a shock to people. Imagine you've paid a freelancer to build your software or your branding or your website. Surely you own it, right? Not necessarily. Under UK law, the starting position is often that the creator owns the intellectual property unless it has been properly assigned. So you might have paid for it, you might be using it, your customers might love it, they might think it's great and associate it with you and everything. But legally, it may not belong to your company. Now imagine trying to sell the business. The buyer asks you, can you show us that the company owns all of its intellectual property, everything it relies on? You can't do it. That immediately creates risk within the business. And buyers do not like risk. Risk reduces value, or at its worst, risk reduces and kills deals altogether. One of the reasons I always encourage founders to think commercially about legal issues is because buyers don't just buy revenue, they are buying certainty. They want certainty over their ownership. They want certainty over the contracts. They want certainty over the customers. They want certainty over employees. The easier you make due diligence, the more valuable your business becomes. The next mistakes are different. These are the mistakes that founders make every single day. And the dangerous thing about them is that they often don't look like legal issues at all. They look like commercial decisions that have kind of gone bad. One day, they're not such a good decision anymore. Let's talk about contractors. I completely understand why founders love contractors. They're nice and flexible, you don't have to commit to a salary, they can start tomorrow, you don't have to think about employment rights a lot of the time, you don't have to worry about holidays, pensions, sick pay, payroll. For an early stage business, that is extremely attractive. It feels like the perfect solution. But here is the question that I always ask. Are they actually a contractor? Or have you simply called them one, given them a contractor agreement, but they're actually an employee? Because those are two very different things. One of the biggest misconceptions in business is that somebody is self-employed because the contract says that they are self-employed. That is simply not how the law works, unfortunately. The courts don't just look at the label that's on the contract or what the person calls themselves. They look at the reality. Who is controlling the work that's being produced? Can they send somebody in their place, or have you really contracted that specific person? Do they work exclusively for you? Do they wear your branding when they're out and about? Do they use your equipment? Are they integrated into your business, into your wider workforce? Do they attend your team meetings? Do they have genuine financial risk? You can call somebody a contractor all day long as much as you like. If they behave like an employee though, the paperwork may not save you in that situation. Now, I'm not saying contractors are wrong or having contractors is wrong. Far from it. It's a really nice, flexible model. And we have clients who quite properly engage contractors every single day. The issue is making sure that the arrangement actually reflects reality. Because if someone works for you for 3 years, Monday to Friday, 9 to 5, using your systems, following your instructions on a daily basis, attending your team meetings, and then leaves on bad terms, don't be surprised if they start asking questions about their employment rights. Those conversations become much more expensive than spending an hour getting the structure right at the very beginning. The next mistake I see is weak contracts. Now, this one genuinely amazes me. Founders will spend 6 months perfecting a product. Then they'll download terms and conditions from Google or a competitor website. Or they'll ask ChatGPT to draft something. Or they'll copy a competitor's contract. Please do not misunderstand me. AI is an incredible tool. I love it. I use it every single day. But AI does not know your business. It doesn't know your commercial model. It doesn't understand what you're trying to create. It doesn't understand your risk profile, not fully. And it certainly doesn't know the promises that your sales team are making. The best commercial contracts aren't necessarily the longest or the most complex. They're the ones that accurately reflect how your business actually operates in practice. One thing I see constantly is businesses having excellent legal clauses covering completely the wrong risks. They've got 15 pages on boilerplate provisions that they got off Claude. They've got force majeure, entire agreement clauses, they've got jurisdiction, but nowhere does the contract actually explain what the customer is buying, what success looks like as part of the commercial arrangement, what is included, what is excluded, when the work ends, what happens if the customer changes their mind, or what happens if the scope changes halfway through the running of the project. Those are the clauses that actually prevent disputes happening. Not whether notices have to be served by recorded delivery, although that's a whole podcast episode in itself. I'll give you a very simple example. Imagine that you are a consultant. The client is asking you for help implementing a new CRM system. Halfway through the project, they decide that they also need some staff training. Then they'd like reporting dashboards. Then they'd like integrations. Then they'd like ongoing support from you. Nobody updates the contract. You just agree between yourselves. Nobody discusses fees. 6 months later, the relationship breaks down. You might miss a deadline or something goes wrong. The client says, well, I thought that was included. The consultant says, no, it wasn't. Obviously it wasn't. The contract doesn't say. But now you've got a legal dispute because you did agree it. When in reality, You had a communication problem, not a legal problem, you had a communication problem. And that's something that I've become increasingly convinced about over the years, is that many legal disputes don't begin as legal disputes. They begin as mismanagement of expectations. One side expected one thing, the other expected something totally different. Nobody realised that there was this gap until money became involved. That's why I often say to clients, good contracts don't just allocate legal risk, they improve communication between the parties. The next mistake I see is one I think founders massively underestimate, and that is giving away control without actually realising it. Now, people often assume control is simply about percentages on a cap table. If I own 51%, I control the business, right? Sometimes, but not always, because governance matters just as much as ownership. I've seen founders own the majority of their shares, yet they find themselves unable to make important decisions on their own. Why would that be the case? It's because of the way the constitutional documents for the company were actually drafted. Look at reserved matters, director approval, voting thresholds, investor protections. All are perfectly sensible in isolation, but when you hold them all together, they can fundamentally change who actually controls a business day to day. That's why whenever someone says, I'm giving somebody 20%, my next question is never, how many shares is that? It's actually, what rights are attached to that 20%? Not all shares are equal. Some carry voting rights, some don't. Some have enhanced rights attached to them, known as preference shares. Some have economic rights only, so they're only getting cash. As I mentioned, some have preference shares, some have different dividend rights. That's why I always encourage founders to stop thinking purely in percentages. Ownership is really only part of the conversation. Rights are the other part. Now let's imagine the business is growing. You've hired staff in, you've signed customers, they've signed up to your contracts, revenue is increasing, things are going well, everything feels fantastic, you're starting to see real progress. Then an investor appears. This is exciting, isn't it? Until due diligence begins. Honestly, due diligence tells you everything you need to know about how well a business has been run. Because buyers and investors don't look at your business the way that you do. They don't look at the potential it has, the ideas you have. They look at the cold, hard risk, and they're incredibly good at finding it. I sometimes describe due diligence as turning all the lights on in the business. All of a sudden, every single missing document becomes visible, every single missing piece, every undocumented arrangement, every verbal agreement, every contractor without an IP assignment, every missing employment contract, every unclear customer agreement, every company's house filing that was never made or made wrongly, the bane of my life, everything. And founders often say exactly the same thing. Oh, I just didn't think that mattered. I didn't think it was important in the grand scheme of things. Unfortunately, the buyer does. One of the saddest conversations I ever have is with founders who've spent 10 years building an incredible business only to discover a buyer wants to reduce the purchase price because the legal housekeeping just isn't there. Nothing's actually gone wrong with the business. Nobody's suing anybody. The business is really profitable, it's doing really well, customers are happy, but uncertainty has value, or rather it destroys and erodes value. Because if a buyer thinks there's a 10% chance of inheriting a problem, they will either reduce the price, or they'll ask you to give extensive warranties and indemnities, or they'll hold money back after completion, or a combination of all of them. All because of issues that could have been fixed way easier years earlier. Which brings me on to another point. Founders often think that lawyers just create paperwork. I actually think good lawyers create optionality for the business owner. Because if your house is in order, you can raise investment, you can sell the business, you can acquire another business, you can bring in and attract senior staff, you can franchise your brand, you can expand internationally. You have options. Poor legal foundations do not just create risk, they reduce opportunity for you as a business. And finally, let's talk about one mistake that almost nobody considers: building a business that depends entirely on you. Now, at first glance, that does not sound like a legal issue. It sounds like a commercial one, but it absolutely becomes a legal issue. If every customer relationship sits with you, every contract comes through you, every decision needs your approval, every negotiation depends on you, then the business hasn't really become an asset. It's become a job. A very well paid job, perhaps, in some situations, but nonetheless, still a job. One of the biggest legal and commercial objectives as businesses grow is making them transferable. Transferable to investors, transferable to buyers, transferable to management, because ultimately that is what is creating the value in the business. So we've talked about the mistakes, we've talked about giving away equity too early, we've talked about not having a shareholders agreement in place, we've talked about poor contracts, contractor issues that can arise, not owning your intellectual property, weak governance, poor due diligence preparation. But if I were starting a business tomorrow, what would I actually do? Because that is the question that founders really want answered. Not what can go wrong, but instead, what should I do? The first thing I do is get brutally clear on ownership. Who actually owns this business? Who deserves to own this business, which is sometimes more important? Who is genuinely taking the risk here? Because I think founders sometimes confuse effort with ownership. Someone might work incredibly hard, but that doesn't automatically mean that they should become a shareholder in your business. Likewise, someone might have fantastic ideas. That doesn't necessarily justify equity though. Ownership should reflect long-term value creation, not simply turning up early. I often tell founders something they find slightly uncomfortable. Equity is the most expensive thing that you will ever give away. It's not salary and cash in the bank. It's not bonuses. It's not dividends. It's equity. It's an ownership stake in your company. Because salaries can stop and bonuses can stop, but equity keeps paying forever. Imagine your business sells in 10 years' time for £20 million. Giving somebody 10% today doesn't cost you 10% of today's business. It costs you £2 million. Suddenly, those conversations about just giving them a few shares feel very different. I hope this is helpful. I hope you have found today's episode really helpful and really tangible and something that you can use going forward. If you'd like to get in touch, you can at info@jamiesonlaw.legal. If there's other topics that you would like us to cover, please do let us know. I hope you've enjoyed this episode of the Legal Leverage Podcast, and I look forward to chatting soon.